2 winters ago, a flatbed driver out of eastern Tennessee walked away from a Kentucky way station holding a stack of paper that was going to cost him $10,000. 3 violations on a Level 1 inspection report, plus a ticket for following too closely. He paid $140 in court costs instead, and not one of those violations ever reached his federal record. No lawyer, nothing bent. 2 free government processes, and 1 20-minute conversation in a courthouse hallway. There are 5 doors like that one, and every single one of them sits in plain sight inside federal regulation and ordinary county traffic court procedure. Today I'm walking you through all 5, who qualifies, what you actually have to file, and the 4 mistakes that turn a $200 ticket into a disqualified license and a truck sitting cold in the yard. And if you hung the keys up years ago, but you still carry the license in your wallet, stay with me. Because the thing almost every driver gets wrong about this rule is assuming it only applies when they're behind the wheel of the truck. This doesn't start with the ticket. It starts with a rule written into federal law about 20 years ago that quietly took away the one thing every other driver in America still gets to use. When a regular driver gets a speeding ticket, he usually has a way out. He pays a little extra. He sits through traffic school on a Saturday morning in a county building with bad coffee, and the whole thing evaporates before it ever touches his insurance. Millions of people do this every year. It's the single most common piece of driving advice in America. A man with a commercial driver's license cannot do that. Federal regulation prohibits states from what the rulebook calls masking. That means a state is not allowed to offer a CDL holder, a deferral, a diversion, or a driving school arrangement that keeps a conviction off the record. It has been that way for roughly 20 years, and it applies to every state that wants to keep receiving its federal highway money, which is all of them. Now here's the part that catches semi-retired drivers flat-footed, and it's the reason I told you to stay with me. That sealed door follows the license, not the truck. A ticket in your own pickup on a Sunday afternoon, coming back from your daughter's house, counts exactly the same as a ticket at 80,000 pounds on the interstate. So if you keep the CDL current for seasonal work, for the 2 months a year you run grain, for hauling a neighbor's equipment on a gooseneck, the trap is still sitting open underneath you. Same rules, same record. Nobody sends you a letter about it when you cut back to part-time. Now stack up what a conviction actually means, because the federal definition is wider than most drivers think. It's not just a guilty verdict in front of a judge. Forfeiting bond counts, paying the fine counts. When a driver writes a check at his kitchen table and mails it to a county courthouse to make a ticket go away, he has legally convicted himself, and that conviction counts against him inside a 3-year window. Then the costs start arriving in layers. There's the fine itself, which is usually the smallest number in the whole equation. There's the insurance side, where the carrier's premium climbs and the surcharge gets passed down to the driver, sometimes as a raise that never quite shows up. There's the safety score, because that violation feeds a federal database that shippers, brokers, and every future employer can pull up on a screen. And then there's the piece that ends careers, which is that certain violations are classified as serious traffic violations. Speeding 15 miles an hour or more over the limit, reckless driving, improper lane changes, following too closely, holding a phone behind the wheel. 2 of those inside 3 years is a 60-day disqualification. 3 of them is 120 days. 60 days without a license for a man who owns his own truck with a payment on it is not a fine. It's the end of the business. So when I say $10,000, I'm not being dramatic. Add the fine, 3 years of surcharge, a safety score that quietly costs you the good freight, and the risk of a stack that parks you for 2 months. That's the real number attached to the piece of paper an officer hands through your window. The good news is that the same rule book that built the trap also built 5 doors out of it. 4 of them clean up damage after the fact. The 5th one is different because the 5th one stops the paperwork from ever getting written and it's the one drivers were never properly taught. Hold on to that. We'll get there. Method 1. Amend the charge before it ever becomes a conviction. This is the door that flatbed driver walked through, and it's the one that applies to nearly every driver watching this. Since traffic school is off the table for you, the entire fight has to move earlier in the process, back before there's anything to forgive. What you want is for the charge itself to turn into something that isn't a moving violation. In county traffic courts across this country, prosecutors amend charges every single day. A following too closely citation gets amended down to a non-moving equipment violation. A speeding charge gets reduced below the threshold that makes it serious. The fine sometimes goes up rather than down. The court costs get added on top, and the driver walks out of the building having paid more money than the original ticket was worth. He also walks out with nothing on his commercial record. Drivers assume prosecutors won't do this. In practice, a county prosecutor standing in a courthouse hallway on a Tuesday morning has a docket 40 cases deep, a courtroom that needs to be empty by noon, and no personal stake in whether one out-of-state truck driver keeps his career. What he wants is a resolution and the county's money. A driver who shows up in person, on time, dressed decently, holding a clean printed record and asking politely, is handing him exactly that. Two conditions make this work. You show up and you plead not guilty first. A driver who mails the check has already convicted himself, and there is nothing left on the table to negotiate. A driver who pleads not guilty has created a case, and cases get negotiated. Now, this varies more than anything else in this video. Some states restrict what a prosecutor can amend for a CDL holder specifically, and some counties have a standing policy against it. Call the clerk of that court before you drive anywhere and ask how they handle commercial cases. And if the courthouse is 9 states away from your kitchen, this is the one situation where a local traffic attorney earns his fee several times over. Because in most jurisdictions, he can appear on your behalf, and you never leave the truck. $200 to keep a serious violation off a commercial record is the best return on money in this entire industry. But beating the ticket in court only handles the state's half of the ledger. It does not automatically touch the federal half, and that surprises almost everybody. Which brings us to the door that most of the industry has vaguely heard of and almost none of it has ever actually used. Method 2. The request for data review, better known as data queues. Pay attention to this next part, because it explains why so many drivers who won in court still ended up with a damaged record anyway. When you get inspected at a scale house, 2 completely separate pieces of paper get created. One is the citation, and it goes to a county courthouse. The other is the roadside inspection report, and it goes into the federal safety database that tracks your record and your carrier's record. Those 2 files do not talk to each other. Not automatically, not ever. A driver can walk into a Kentucky courtroom, get his citation dismissed outright, drive home genuinely believing the matter is closed, and that violation is still sitting on his federal inspection record 3 years later, quietly dragging down the score that brokers and future employers look at. Data queues is the federal system that fixes this, and it costs nothing to use. Any driver or carrier can file a request for data review, challenging an inspection violation or a crash record. It runs online. The state agency that wrote the inspection reviews it, and if you're right, the record gets corrected. 2 reasons a challenge succeeds. The first is what the system calls adjudicated citations. If the citation attached to that violation was dismissed, or you were found not guilty, the violation can come off entirely. If it was amended down to a lesser charge, the violation description gets changed to match. That's exactly why Method 1 and Method 2 are built to be used together. You win in court, then you file the paperwork that forces the federal record to reflect what the court actually decided. The second reason is plain clerical error, and there's far more of it than anybody in enforcement wants to admit. Wrong vehicle identification number. A violation attached to a truck you weren't driving. A license number with 2 digits transposed. An inspection logged against a company that sold that tractor 18 months earlier. I'll give you the version of this that happens constantly. A driver pulls his own record for the first time in years and finds a brake violation from a state he's never hauled through, attached to a man with the same last name and a license number 1 digit off from his own. He'd been carrying it for 2 seasons. He filed with the inspection number and a copy of his own license, and it was gone in about 3 weeks. That's not a loophole. That's a filing clerk fixing a typo, except nobody ever told him the form existed. And if you drove for 30 years and finally hung it up, this is the part worth sitting with. Every crash somebody else caused, every inspection that belonged to another man, every violation a court threw out that stayed on your file anyway. There was a free federal form the whole time. It was never explained to you at the roadside, because the roadside is not where they explain things. File as soon as you're able. Some states apply their own deadlines, and the data only sits in the scoring window for about 2 years regardless, so time is working against you. When you file, be boring and be specific. Attach the court disposition, the inspection number, the date, the location. The adjudicator reading it has a stack of these on his desk. The clean, unemotional filing with the document attached is the one that gets approved. That handles tickets and inspections. The third door handles the thing that scares drivers more than any citation ever written. Method 3. The Crash Preventability Determination Program. Every commercial driver knows the feeling of a crash that was not remotely his fault. A car crosses the center line. Somebody runs a red light into the side of your trailer. A driver clips you while you're legally parked in the back row of a truck stop at 2 in the morning. A deer comes out of the ditch at dusk on a 2-lane. For years, the federal safety system counted those crashes against you anyway. It did not care who caused it. If your truck was involved, it went on the record, and it stayed in the screening report that employers pull for 5 years. That changed. There is now a formal federal program where a driver or a carrier can submit a crash for a preventability determination. If the crash falls into one of the eligible categories and the evidence backs you up, it gets marked not preventable, and it stops counting against your safety measurement. The eligible categories cover most of what actually happens out there. Being struck while legally parked, being struck in the rear, being struck by a vehicle that crossed the center line or ran a control device, being struck by an impaired or a distracted driver, animal strikes, infrastructure failure, like a bridge or a road surface coming apart, being hit by a wrong-way driver. The submission goes through that same data queue system, and the whole thing lives or dies on evidence. A police report assigning fault to the other party, photographs from the scene, witness statements with phone numbers on them, and above everything else, video. Because a submission with 30 seconds of footage of a car drifting across the center line is close to automatic, and the same submission without it becomes one man's word against another's 6 months after the fact. Whatever you've got, gather it in the first hour, because none of it gets easier to find later. If you're getting something out of this, hit subscribe. I break down one of these industry rules every week. And if you've got a son or a nephew or a grandson running a truck right now, send him this one, because these are not things anybody teaches him at orientation. Method 4. The corrections available to you right there at the scale house. Weigh stations produce an enormous share of the fines written in this industry, and overweight penalties in many states are graduated, which means the fine climbs with every pound you're over. A few hundred pounds is a nuisance. A few thousand pounds can be a 4-figure ticket in a single afternoon. The first thing worth knowing is that in a lot of states, an axle weight problem is correctable on the spot rather than automatically citable, as long as your gross weight is legal. The load is legal. It's just sitting in the wrong place on the trailer. Sliding the tandems moves weight between the drives and the trailer axles, and a driver who knows his own trailer can often fix an axle overload in 5 minutes out in the lot. Officers vary in how much rope they'll give you, and the rules genuinely differ state to state, so check how yours handles it before you count on it. The second thing is that you're generally entitled to know how that number was produced. Scales are certified equipment, and certification has a date attached to it. Asking politely for a reweigh or asking whether the certification is current is a normal request and not an accusation. Some states have a formal procedure for requesting a second weighing on separate certified equipment. The third thing is just prevention. Owner-operators who scale the load at a truck stop before they ever hit the interstate and who keep that printed ticket in the cab almost never take an overweight hit. $12 or $13 at a certified scale beats a four-figure fine every time, and the ticket in your hand is a document you can produce later. That's the fourth door. Now the fifth one, the one I told you to hold on to, because it's the only one that keeps you out of the other four entirely. Method 5. Use the exceptions that are already written into the hours of service rules. Log violations generate some of the ugliest penalties in this business. The federal penalty schedule for falsified records of duty status runs well into 5 figures per violation, and that's before the state gets involved. Drivers get hammered here, and a shocking amount of it is avoidable because the regulations contain legal flexibility that most drivers were never properly taught. Start with the adverse driving conditions exception. When weather or road conditions you could not have known about before dispatch slow you down, snow, ice, an unexpected closure, you're permitted to extend your driving time and your window by up to 2 hours. That's a legal extension written into the rule, not a gray area you're gambling on. Then there's the 16-hour short-haul exception for property carriers, which gives you one extended day inside a 7-day period when you return to the same reporting location you started from. Then personal conveyance, which is the one drivers get wrong more than any other. Moving the truck while off duty for personal reasons. Finding a safe place to sleep after a shipper tells you to get off his lot at 11 at night. Driving to a restaurant near where you're parked. Legitimate personal conveyance is off-duty time. The line is whether the movement advances the business. Driving toward your delivery is not personal conveyance no matter what you type into the log. And then the split sleeper berth provision, which lets you break your rest into 2 qualifying periods instead of 1 solid block, and which is very often the difference between a legal delivery and a violation on a bad traffic day. Here's the piece that ties this whole section to everything else in the video. The annotation is the defense. When you use one of these exceptions, you write the reason into the electronic log at the moment you use it. Ice on the interstate outside Laramie. Road closed at the summit. Extending under adverse conditions. That note, typed in the cab while the wipers are running, is the document that ends the argument during an audit 8 months later. Because here's what an auditor sees when there's no note. A driver who legally extended 2 hours in an ice storm and a driver who simply ran over his hours look completely identical on the screen. Same numbers, same shape, no explanation. The auditor is not going to assume the ice storm. He's going to assume the second one. And he's going to be sitting across a table from a man trying to remember a Tuesday from last winter. 40 seconds of typing at the time is the entire difference. So those are the 5 doors. Now let me spend a few minutes on the mistakes, because for some of you, this section is worth more than everything that came before it. Mistake number 1, and it's the one that costs drivers the most money in this country by an enormous margin. Do not pay the ticket just to make it go away. Paying the fine is a conviction under the federal definition. That check in the mail is a guilty plea with a stamp on it. Every year, thousands of drivers pay a $150 citation to avoid losing a day of work, and then spend the next 3 years paying for that decision through insurance, through lost freight, and through job applications that quietly go nowhere. Plead not guilty first. You can always negotiate afterward. You cannot unconvict yourself. Mistake number 2. Ignoring an out-of-state citation because you don't live there and don't ever intend to go back. States share this information through interstate compacts. An unpaid or ignored citation in a state you'll never see again turns into a failure to appear, and a failure to appear suspends the license your home state issued you. Men have lost careers over a ticket in a county they couldn't find on a map. Mistake number 3. Talking at the roadside. You are being recorded by their equipment and probably by your own. Signing a citation is not an admission of guilt. It's an acknowledgement that you received the paper, and refusing to sign accomplishes nothing except turning a routine stop into something else. What actually does damage is explanation. Every sentence about how far you'd driven, how tight the schedule was, or how long it had been since you last slept becomes evidence that closes off the amendment we talked about back in Method 1. Be polite, be brief, hand over your documents, and save the argument for a courtroom where it counts for something. And mistake number 4, never once looking at your own record. Any driver can request his own pre-employment screening report for about $10. It shows 5 years of crash data and 3 years of inspection data, and it is the exact document a prospective employer reads before he decides whether to call you back. Drivers who pull it once a year regularly find violations that were dismissed in court, crashes somebody else caused, and inspections belonging to a completely different man with a similar name. You cannot fix what you have never read, and the fellow across the desk at your next interview has already read it. Here's what I want you to take from all of this. Right now, in a county courthouse 3 hours from where you're sitting, a prosecutor is amending somebody's charge before lunch. In a state office building somewhere, a clerk is correcting an inspection record because one driver filled out a free form. None of that is hidden. It's printed in the same rulebook that gets quoted at you through the driver's side window, just in the chapters nobody reads out loud at the scale house. Pull your own screening report this week. It costs about the price of lunch, and it takes 20 minutes at the kitchen table. Most drivers who do it for the first time find at least one thing on there that shouldn't be, and now you know exactly which door to walk through to get it taken off. If this was useful, subscribe, because next week I'm covering what actually happens during a DOT compliance audit and the 3 records that decide the outcome before the auditor ever sits down. I'll see you there.